Hello everybody, in this class we're going to cover the First through Third Amendments. So without any further ado, let's go ahead and jump right in. As we talked about last class, the First Amendment says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. We can break this down into the following rights. The first two can kind of be read together. It's the Anti-Establishment Clause and the Free Exercise Clause. But they mean very different things. A lot of people think that government can't ever do anything with respect to religion, which simply isn't the case. Merely the government can't establish a religion. They can't say that this is going to be the religion of the land or promote one religious ideal over the other. The government still, however, has, to a certain extent, a right to freedom of speech. They can decide what particular statues they want to put in an area when it's the government paying for it. If, on the other hand, the government's created an open forum where they allow citizens to put up statues, well, that gets a little trickier. In that case, then the government has to allow everyone to participate in that open forum. Really weird laws related to how the government establishes a religion, but what you need to keep in mind is this. If it's the government doing the talking, they have the ability to prefer one idea over the other, but they can't do anything to try and force the people to follow that idea. If the government has created an environment that you can talk or other people can talk, they have to be open to all people who might want to talk. If Lincoln University, for example, decides that they want to allow students to have student organizations, which they do, and they permit the Young Catholics Association to create a club, then they also have to permit the Young Satanists Association to create a club. You can see where this is sometimes why government agencies say, nope, we're just not going to do religion at all. The Free Exercise Clause, on the other hand, limits what the government can prohibit people from doing. The government can't say you can't have a particular type of worship service or you can't meet in a particular location. I mean, I guess they could to a certain extent, but this can't be based on religious beliefs. For example, we don't really, most of us probably don't really subscribe to Satanism, but the government can't say that that particular form of worship is going to be excluded. They can put certain limits on the sort of worship you can do. For example, if human sacrifice is part of your religion, you can't do it. Similarly, the concept of female circumcision is pretty much outlawed in the United States, even though it has a religious basis. So now we get into the second part, which I like to think of as altogether the freedom of speech. But this is, the government can't limit speech. They can't say that I can't criticize something I don't like or I can't have an opinion about things. Similarly, the press has the right to print what the press wants to print. But these two together, and we'll touch on assembly in a minute, these two together do have limits, and the limit is called defamation. While the government can't limit what I say really about them, it can enforce laws that protect the reputation of other people and entities. For example, if I say downright lies about somebody else, that would be called slander. Slander is going to be spoken untruths that harm the reputation of someone else. Libel is if I print it. When we're talking, when the press is talking, or when the press is writing, it has to be cognizant of the fact that defamation is permitted, even though we have a constitution saying we shall have freedom of speech and freedom of the press. But this is usually a pretty hard hurdle to pass. One, the person who's claiming that I've defamed them has to prove that what I said was untrue. That's a very hard thing to do. It's very hard to prove a negative. Most of the time, it's impossible to prove a negative. Prove it's not raining outside right now. you guys can't see out my window. You don't know what's going on. There is no way you can prove that at this moment it's not raining as I record this video. But there are some things that you can prove that it's more likely than not that it's false. Prove that I'm not speaking to you from the moon. Yeah, that's probably a lie. And if I'm lying about myself, that's one thing. But if I'm lying and causing damage, that's something else. And damage is the second element. The things that I say that are untrue have to actually harm you. Famously in the news at the moment, you might have seen that Fox News just paid a massive settlement to Dominion Voting. Fox News published multiple times that Dominion Voting helped basically win an otherwise legitimate, or helped Donald Trump lose an otherwise legitimate victory. Basically that the entire election was a fraud, Dominion Voting was in on it. Well, that is slanderous if it's spoken, libelous if it's in print. In this case, it did massive damage to Dominion Voting. Who wants to hire this company that everybody now thinks is worthless? So, yes. And then the third element is that in order to prove defamation, you have to prove that the statements that were made actually caused the damage. I know this seems backwards, but suppose I was a terrible businessman and I sued somebody for saying Andrew's a terrible businessman. But it turns out I actually was like swindling people left and right. Somehow they proved that I was a good businessman, but my reputation was actually damaged because I was swindling people. You know, in that case, we can't establish that the defamation was the proximate cause of the damages I suffered. So speech and press have its limits, as does assembly. When we talk about the right to assemble, that is peaceably assemble. That doesn't mean that we have an absolute, unabridged right to get together and do whatever we want. We can protest, we can chant, we can hold signs, and those are proven by history to be significantly impactful. We can't loot, we can't burn the city down. Even when we have things that we would really like to do that over, that's not constitutionally protected. And finally, and I don't think this is really used so much anymore, we have the right to petition the government. In Missouri, we actually have initiative petitions where if you want the Constitution changed, you can write a petition and we can change the state's constitution because of that petition. If you are a person who enjoys marijuana, that is how the right to, or basically the ability to have marijuana came into effect. Citizens got together and they said, this is ridiculous. We want to be able to smoke marijuana. And they went together, circulated a petition, and it made it to the ballot. It passed the ballot initiative. So now, constitutionally, Missouri is a recreational marijuana state. At the federal level, you have a right to petition, but the government doesn't have a mechanism where they have to necessarily listen to you. At the state level, like I said, if you have a petition, you can get something changed constitutionally. There's not really any similar petition federally, but still, it's a good thing that you can call up your senator or representative and say, you know, we don't like what you're doing, stop. There are countries in the world where that is not something that's tolerated. For these cases, I had you go over, or for the cases for this, I had you go over two. And I did that because it illustrates a unique dichotomy that I hope you all picked up on. In Minersville School District versus Goblets, or Gobetis, I don't know, the pronunciation of that has always eluded me, we have a case where some Mormon students refused to salute the flag. We have the exact same fact pattern in West Virginia State Board of Education versus Barnett. But there's a very different outcome in these. In the 1940 case, the Minersville School District, it was held that, yes, forcing somebody to salute the flag may be a slight infringement on their religious freedom, but that's necessary to promote national unity and for other desirable outcomes related to educating students. In West Virginia State Board of Education, however, they took an opposite approach. So while in Minersville they held that this is not violating the free exercise clause, in West Virginia they completely skirted that issue. I think we talked in the very beginning about stare decisis. Courts really don't like to overrule themselves. And this is the Supreme Court making a different decision 3 years later. Notably, though, while the outcome does seem to overrule itself, they do it on two very factually distinct planes. And because of that, it's not really overruling it, is it? It's kind of strange. In West Virginia, what they conclude is that if you have the right to freedom of speech, then you also enjoy the right not to speak. And in West Virginia, they held that forcing students to salute the flag was the equivalent of forcing them to speak. This was making them this was violating their right to freedom of speech. It doesn't talk at all about freedom of religion. It doesn't really address anything more than to say that the reason they don't want to speak is because of religion. But the interesting thing here is that they completely did a 180. I asked you all to contemplate why that might be the case. And then I found out that, surprise, Canvas messed up again, and my questions, which I wrote in the beginning of the semester for you all to answer, haven't been publishing. I hope you did take the opportunity to think through this, though. What world event was going on at the time that these cases were decided? Well, shortly before Minersville was heard, we had German nationalism. We had a country that was on fire with national pride and unity. And this was something that at the time was very desirable. The United States was also very interested in fostering that national pride and unity. In 1943, however, it was seen as very different, because what became national pride and unity turned into fascism. And the whole concept of, hey, we really want to promote something where all the little kids have to dress alike and salute the flag became very reminiscent of what was going on in Nazi Germany. I suspect that is a big reason why we have an about face between 1940 and 1943. I think it's important also to note, when we're talking about the court not wanting to overrule itself, lots of people are going to draw a similarity between this and the Dobbs decision regarding overturning Roe versus Wade. I want to highlight the fact that this did not necessarily overturn Minersville. It simply applied a different rule to get a different outcome. Dobbs explicitly overturns Roe versus Wade. It goes back on that right to privacy, which we've talked about before in the case. It is the court doing a 180 on a decision that it's made. It's not unprecedented, but the times that it has happened are few and far between. Let's talk about the Second Amendment. The Second Amendment says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. When I wrote the questions for this, I asked you all to consider what parts existed based on the Heller decision. And we'll get to Heller in a minute, but let's take just a second to break that down. Scalia in the Heller decision breaks this into two halves. The first half is the prefatory clause. The prefatory clause is there to give context and meaning to the amendment, but it doesn't actually give you any rights or tell you anything about it. In this case, a well-regulated militia being necessary to the security of a free state is the prefatory clause. The Founding Fathers would like if we had a well-regulated militia so that the government couldn't just do whatever they want. But that doesn't really tell us that that's constitutionally mandated or even constitutionally protected. We can ignore it. We can use it to understand the context of the following phrase, but we don't have to apply it. The operative clause, the thing that actually we do have to follow, says the right of the people to keep and bear arms shall not be infringed. shall not be infringed is easy. We can say, okay, that just means that we can't take it away, we can't violate it. But Scalia breaks it down further and looks at the meaning of what arms means, what keep means, and what bear means. Ultimately, what he concludes is that to keep and bear arms mean that you can have a gun and you can carry it around with you so that you can defend yourself. It has to be capable of firing. The government can't say, okay, well, you can keep and bear arms as long as we have all the bullets, because that would defeat the purpose of the amendment. Again, here, to keep means to actually possess, and to bear means to carry around. Arms, that's very loosely defined. And I don't think Scalia does any job at all of trying to narrow that down. In fact, conservatives typically like that to be broadly construed. But let's talk a little bit about why this is a big deal. This is currently something that's in major flux in the country. The right to bear arms has continued to expand and contract over the course of the last 30 years or so. To put it into context, Heller is probably the most significant case on the Second Amendment ever, except for in the last term. And this case is not yet old enough to drive. It's 15 years old. So I guess Heller could get a learning permit. But it's nuts when you think about how most of our Second Amendment litigation has taken place in the last 20, 30 years. Last year, we saw a major change by the Supreme Court because they created a new test when looking at gun regulation, and that's the historic context case. It is perfectly fine to have gun regulation, the court said, but in order for it to be constitutional, you have to be able to point to something that was an analogous restriction at the time that the Constitution was signed. Well, that just doesn't make any sense, because whose Constitution are we talking about? Well, I'm sorry, what area are we talking about? Because just like we do now, different territories had different standards. And whose version of history are we talking about? Certainly if someone were to come into the world with a machine gun in 1776, there would be some pretty heavy laws about it. Speaking of which, little side note, did you all know that the only weapon outlawed by the Catholic Church is the crossbow? At the time that it was invented, the Pope decided it was too good at killing people and outlawed it. So if we're going by that historical context, then we can outlaw things that are deadly. There's a lot of open area here. It's going to be the subject of more litigation in the years to come. And basically, what does the Second Amendment mean? It's up in flux. We already talked about DC v. Heller. There's the link again. Please give it a read just so you can see. I mean, I don't necessarily always agree with Scalia. He's an originalist, so he tries to discern what the Constitution means from the perspective of the people who wrote it. Not really how it applies to today's standards, but it is fascinating to see the way his mind worked and look at what that originalism thing is all about. Finally, the Third Amendment. This says no soldier shall in time of peace be quarantined in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. There's been like no cases on it. And that's because while this was a big deal during the Revolutionary War, in particular with British troops being quartered in American houses, it really kind of fizzled out at that point. And that, to a large extent, deals with the way that we started living. We moved from an agrarian-dominated country where pretty much everybody lived in small, self-sufficient farms to a country that has more urban environments. Certainly, your family doesn't grow all the food they're going to consume for the next year over the summer. And that is probably the way that a lot of Revolutionary era people lived. So, where are you going to put your officers if they come to town? Well, with the homes of the people who have the food to feed them, of course. So, the law kind of changed. There was one case that I can find that dealt with this, but it was a Court of Appeals case, and it dealt with the guards at a prison who decided to go on strike. As part of their compensation, they received a house. They got to stay in the house on site because it was pretty far away. When they went on strike, the governor ordered the National Guard to take over their duties and housed the National Guard in the homes that were on the prison grounds. These homes were owned by the prison, so the government, and ultimately the Court of Appeals didn't even reach the issue of how the Third Amendment applies. They settled the whole matter as a matter of contract law. They said, look, as a term of your employment, you get this house. When you stop working, you don't get the house anymore. It's not a matter of the Third Amendment at all. It's a matter of, are we going to pay you for you not to work? And the answer is no. So that's the only case I can find at the appellate level or beyond. And so there's just really not much to talk about with the Third Amendment. All right, so next, we are going to go over the Fourth Amendment next class. So be sure to read Rodriguez again or look over your notes if you did a good job. Remember, that's one of the first cases I assigned for you all to practice working on. And also, please read Miranda. It's linked below. Miranda versus Arizona. It creates the whole concept of a stop and frisk, very important in the Fourth Amendment context. With respect to your final project, I have one student who's turned it in. They did an excellent job. I hope to see more of them because you too can know how you're going to perform this semester. If you get that in, I'll be able to get everything graded by the end of the term so you can figure out, hey, do I need to redo this video to get some more points, or is it good enough? So please get those videos in. I sent out the upload links. If you have any questions or concerns, please let me know. I hope everybody has a great week, and I will talk to you soon. Goodbye.